My name is Heather Tenney. I'm a partner here at Tully Rinckey, practicing federal labor and employment law, military, and national security law. Ultimately, today, our primary goal is not really to talk about the substance of different federal employment topics, but more the idea of consultations in general, so that you can get an idea of what things may be appropriate to have a consultation with, what things that you need to know about the consultation process, how to best prepare, and timelines that might be associated with it. So let's go to the next slide. And ultimately, as I was saying, these are the things that we hope to cover today and the things we hope you learn as part of this webinar. Ultimately, we intend first to start off with talking about just in general what a legal consultation is, and ultimately about what types of timelines that you should consider when deciding to speak with an attorney, how to best prepare for when you speak to the attorney for the first time, what can happen after the consultation, and then we will get into some details on the specific types of federal employment matters that Tully Rinckey can assist you with and things that may be topics for consultations. So let's dive in. Next slide, please. So what is a legal consultation? Well, at the core, it's really a conversation. It's going to be some scenario where you're allowed to speak to an attorney about various issues that you may have so that you can understand and the attorney can understand what your legal concern is, and ultimately the attorney can advise you as to what your legal options may be in terms of not only from a process standpoint, but also in terms of best practices, next steps, and provide you advice on even potentially moving forward with having representation through that matter. Here at Tully Rinckey, we actually have a staff in our client relations department that you can contact if you have an issue that may be brought up here or a different issue that you would like to talk to with an attorney, and they can schedule you. And because we have such a large group, as a core practice area of ours is federal labor and employment, we often have the opportunity to handle a consultation on a same day's notice for those who are under tight deadlines. But as we will talk about later, the earlier you can identify a potential issue, the better it is to seek that legal advice at that point and not wait until the pressures of that deadline. Next slide, please. So in terms of, did we go to the next slide? Okay, thank you. In terms of what happens during a consultation, what are some of the things that you can expect? Well, number one, obviously, like I was saying before, it's a conversation. So, in many of these situations, the law isn't just a static application of just a rule. It's ultimately the application of that rule to facts. So you're going to share with the attorney the facts of your case, and the attorney is going to review that information with you so they can best identify, number one, what the issue may even be, what types of defenses may exist that the other side may have, as well as strategy for your own case. In terms of, in many of these cases, there may be relevant documents, whether that's an actual action or notice from the agency that you work for or something that you may want the attorney to review, and those are things that can be reviewed together with the attorney and discussed. Now, many of the types of employment issues that we'll talk about today, they have a process and procedures. So the attorney during a consultation is often going to talk to you about what the likely next steps that will occur and the life cycle of your case to include potential outcomes. Now, obviously, there's no crystal ball in these scenarios, so a lot of things are dependent on the way in which the matter progresses, but certainly there's the opportunity to discuss strengths and weaknesses that may exist in the case that you may have. Now, every consultation isn't necessarily going to result in you retaining the law firm to represent you. However, a consultation still is an appropriate option in those cases, even when you might not be looking for representation specifically, because the lawyer can in fact give you advice, even give you potential strategies and next steps, even if you ultimately don't retain the firm. Next slide, please. So ultimately, at the end of a consultation, if there is something that the law firm can in fact assist you with, and you ultimately decide that you're going to proceed forward, what happens is generally you would then speak to our client relations team, and they will prepare and send a retainer agreement, which is the contract for you to review based on what the discussion was with the attorney. Then, if you are in fact moving forward, you'll sign the retainer. There'll be a payment that will be in terms with the retainer agreement that has been discussed. And ultimately, your case would be opened and assigned to one of the experienced attorneys within our Federal Labor and Employment Group. Now, it's also important to, though, recognize that when you retain a firm like Tully Rinckey, you are retaining the firm, not necessarily the individual attorney. So you get the benefit of all the knowledge and experience of the firm. However, obviously, we don't want you to have to talk to 20 different attorneys over the course of your representation. So you get the benefit of having an individual or a small group assigned to your case that then will take the matter forward, progress with the next steps that are often discussed during the consultation itself. Now, often during these consultations, you're obviously speaking to a specific attorney. However, that attorney may not ultimately be the one who winds up representing you through the life cycle of your case. But our consult attorneys here, me included, we always discuss any information that we gain during the consultation with the assigned attorney, to include strategy, to include analysis of different documents, and we take notes throughout the consultation so that then those individuals are well aware. Plus, you'll then have a greater opportunity with the assigned attorney to offer even more information, more documentation, so as they move forward with your case. Next slide, please. So in terms of, when you should talk to an attorney, really the simple answer is as early as possible. If you identify a problem that you're experiencing, you are usually in your best interest to speak to an attorney as promptly as possible. Now, some people often, don't think about talking to an attorney. They go maybe to somebody in their supervisory chain, somebody in maybe human resources. The reason why it is often beneficial to speak to an attorney as early as possible is, number one, there can be very specific deadlines related to whatever the matter that you have is. Plus, also, when you're talking, often to the individuals who work within your agency, you may not be getting the best neutral advice, because the people who work in your agency ultimately are often not there to provide you specific advice based on your best interest. They're there often to protect the agency. So when you want to try and get more neutral advice that ultimately is looking out for your best interest, it's often better to go outside of your entity and speak to an attorney, so that you're making sure that you're getting advice that's not partial to the agency itself. But in particular, if you receive any type of notice, if you receive a notice of proposed disciplinary action, a notice that they want to suspend your access for security clearance, suspend, a duty assignment, that is definitely a time that you want to call immediately and seek out representation, because those things often have very specific deadlines. In the area of equal employment opportunity, like discrimination, you want to be in a position to talk to an attorney as close in time to what you believe the discriminatory event is as possible. And it's not only so it makes the narrative easier to convey with the attorney, it's also because, again, there are a lot of deadlines that exist. And no matter how egregious the event may have been, if you miss those deadlines, no matter how much evidence you have, you may not be able to actually pursue that claim anymore, because it would be barred by, in essence, the statute of limitations. Another reason why it's important to address whether, a claim early in the process and talk to an attorney is mistakes can happen. There can be issues when you're trying to file something that that it doesn't go to the right person. And often that stuff is held against you, not against the organization. So the more time you leave in the process, you're allowing for those mistakes to not be ones that ultimately kill your case. So let's go to the next slide. So in terms of specific areas that may warrant talking to a federal employment attorney, some of the most common issues we're going to talk a little bit about now. So probably one of the areas that we speak to individuals about most frequently is discrimination. So in the federal government process, we're talking about federal EEO claims. Now, EEO claims, that is obviously when you're alleging discrimination, hostile work environment, harassment based on a protected basis like race, national origin, color, sex, sexual orientation, disability, age over 40, religion, previous EEO activity, to name quite a few. When you have some event that you believe is motivated by one of those protected bases, your first step in the federal EEO process is to file an informal complaint. You have 45 days from the alleged event or your knowledge of the event or the effect to file your complaint. So when you're preparing for a consultation or thinking about a consultation, you want to make sure that you're doing so not, on the 45th day or even the 44th day. You want to raise those issues early so that you can then, have the opportunity to best be able to take advantage of the process and make sure that your claim is not dismissed as being untimely. So in the informal complaint, you're often going to be discussing with your consult attorney the different bases of discrimination, when and what types of discriminatory actions have taken place. Now, if you've already filed at the time that you're talking to your attorney, the attorney is also often going to be asking you about where you are in the process. So you could be participating in what they call traditional counseling, and that's where the EEO counselor who works for the agency is informally investigating the complaint and is kind of telling you what they're learning from the agency. Or you could be engaging in mediation or what they call alternative dispute resolution. It can often be beneficial to have counsel represent you during that mediation process. So that's something that would certainly be discussed during a consultation. Now, if the informal process has ended without resolution, you're ultimately going to receive notice of the right to file a formal complaint. Now, it's usually very critical at that point that if you're going to be looking for representation, that you contact the firm immediately, because you have deadlines in which to then file that formal complaint. You have 15 days from the date that you receive the notice of right to file a formal complaint to then file. Now, during that formal complaint, when you're then now filing it, you can ultimately add things to that complaint that have happened since. And in fact, that's very important. If new things have occurred, new discriminatory acts or retaliation for engaging in EEO activity, then you're going to want to ultimately amend that to include those things, or include them now in your formal complaint if you have not already filed. But if you have already filed, again, one of the things that you may be discussing with the consultation attorney is where it is in the process. At the end of the formal complaint, if it has not been resolved, the complaint, if it's not settled with the agency, you're going to receive a report that they call an ROI, a report of investigation. Now, if you've received that, you're going to have 30 days from the date of receipt to then make your choices on whether or not you want a final agency determination, or if you want to go to the EEOC for a hearing. So that's another time that if you haven't already spoken with an attorney or retained counsel, you may want to do so that you can discuss your options and potentially having representation moving forward. Now, once you get to the hearing stage at the EEOC, if that's what you elect, there's going to be, up to the point of the hearing, there's not as much kind of legal issues that come up. You're generally just telling your story. However, once it gets to the hearing stage, even though it's an administrative proceeding, it has all the trappings of legal process. You'll have to engage in what they call discovery, which means you're going to have to draft, request, respond to request in a legal fashion. There's going to be deadlines for those things. You're going to potentially receive orders that you're going to have to respond to from the administrative judge. There may be conferences scheduled that you have to participate, and all these things are going to be things that you're going to want to discuss with an attorney and potentially seek out representation for, because not only do they have deadlines, they often require a certain level of subject matter expertise that, if you're not handling these things on a day-to-day basis, might be too much, especially if you're still having to do your day-to-day job while all this is going on. Ultimately, there can also be motions during the EEOC hearing process that include a motion to dismiss, or what they call summary judgment. A failure to respond to those things timely could ultimately lead to your case being dismissed. And obviously, the hearing itself, it can be very beneficial to have representation and certainly discuss what's going on through a consultation at that point, because you're going to then be responsible for having to call witnesses, question those witnesses, make arguments, introduce exhibits, which again is often something that can be very difficult for somebody who has not been trained to do so and does not do so on a regular basis. Now, after the hearing, or if the case is dismissed for any reason, you often have appeal rights, and that's something that you would also want to discuss with an attorney, because those have deadlines associated with them. They obviously have legal standards that need to be met. So that's another thing, and that's what's called appealing to the Office of Federal Operations, or OFO. Next slide, please. So in terms of what can make a EEO consultation successful, what things should you be prepared for, and what things should you do in anticipation of your consultation? Well, number one, it's a good idea to, we talked about before that a consultation is a conversation, but it's also not a good idea to just come in with sort of no plan of how you're going to discuss and how you're going to convey the information, especially when it comes to events related to your EEO claim. You're going to want to know what the specific dates are related to the discriminatory events, because like I was saying before, there is a deadline associated with filing. So it's very important to know when things occurred, and know, operative facts, the who, what, when, where, because those things are going to be important in the formulation of your complaint and determining whether or not you even have a viable complaint to pursue. And a way to do that, as opposed to trying to come up with everything off the top of your head, is to draft a narrative description of the events that are taking place, the things that you're complaining about. Now, that doesn't replace the discussion that you're going to have with the attorney during the consultation, but it can be a roadmap for you to use in order to best convey, and that the attorney can then follow along with you, so that you're not, struggling to try and remember when some certain event happened, or who was involved, or where it might have occurred, because you've had that time to reflect on it prior to the consultation and drafted that roadmap for yourself. Now, obviously, if the case is further along and you've already filed, or you could already be at the EEOC, it's important that if you have any document that you've received either from the agency or the administrative judge, that you send that documentation prior to the consultation. So this can allow, number one, the attorney to identify any deadlines that may be outstanding, also any requirements that you may be, in need, and also be able to establish what the different legal issues that may be at issue are, as opposed to you trying to have to interpret that yourself. Part of the reason you're obviously talking to an attorney is so that the attorney can help you understand the things that you may have received. Now, obviously, much like anything, be on time and be ready to discuss the issues. Now, sometimes people are obviously nervous, and that's fine. This is, but a consultation is usually a pretty friendly environment. This is not a situation where it's adversarial in any way, but one of the things in being nervous is sometimes people don't want to open up about their facts, and that really can inhibit what the successfulness of that consultation can be if the person isn't open to sharing, because unfortunately, as much as I would like to be able to, I cannot read people's mind. So the more opportunity and discussion that we are able to have, the better that we're able to identify what your issues are and give you advice, strategy, and a way ahead. Next slide, please. So another common area that is rife for consultation and is something that we obviously hear a lot about are, in the area of proposed disciplinary action. And that can start even before a proposed disciplinary action is given. That can be just for an investigation itself. So if at any point you ever are notified that, maybe you're being put on administrative leave, or you're being sent home on telework, or you're being advised that there's something that they're looking into, or you actually get notice that you're under investigation and they want to interview you, that is a good time to speak to an attorney. Because again, the people who you are often talking to from the agency in that situation are not necessarily looking out for your best interests. They're trying to gain information, and that information could ultimately lead to some type of disciplinary action. Now, sometimes you know very little about the nature of that, but that sometimes is the reason that you do want to talk to an attorney, so that you can understand potentially why an attorney getting involved at that stage may be the best strategy for you, because you're often going to face more opportunity to gain more information and have the more opportunity to negotiate and share your side of things through representation than you would be alone. And also you want to obviously know what your rights are, what types of things, can be, can happen as a result of whatever's going on. And that's what, an attorney can do for you during a consultation, is explain those things. Now, obviously, if you actually have received some sort of proposed disciplinary action, and that could be a reprimand, it could be a proposal for suspension, demotions, a proposal for removal, those are definitely things that you would want to talk with an attorney about. You would want to provide the documentation related to them, and also recognize that it's not something you would want to delay in having a discussion with, because the timelines for response to these types of actions are often very limited. You're usually talking about anywhere from 7 to 14 days. You're going to have a response without gaining some sort of an extension for time. So you do not want to wait until the last minute. Now, if you do wind up facing, it's no longer at the proposal stage, but you've actually received a decision, and you ultimately are in a position where you're wanting to object to that decision, depending on what it is, you have certain types of an appeal. Now, there can be appeals that can be based on what you think the motivation is. If you think that the reason behind what happened was, say, what we were just talking about in terms of EEO, you think it's discriminatory or retaliation for engaging in EEO activity, you may be filing another EEO complaint based on what has happened with this proposal for discipline. If it's something like a removal or a suspension that's more than 14 days, or a demotion of a pay grade, you may ultimately have the right to appeal to what they call the Merit Systems Protection Board. So that's something you would want to discuss. There also could be other issues, and you want to make sure that you're then talking to an attorney about what your options are. And that's something that you would also want to do very quickly, because there are timelines. Those timelines are usually 30 days from the date that you receive the decision, or the effective date of the decision. But it could be shorter depending on your agency. It could be longer depending on the theory of attack. If you're doing an EEO issue, it could be a 45-day deadline. But you never want to be in a position where you're waiting to the last minute, because you want to keep all your options open, and you want to make sure that whatever claim you have is not ultimately being dismissed, not on its merit, but just because it was untimely done. And if it goes to something like the Merit Systems Protection Board, much like the EEOC, there are orders, there's discovery, there's hearings. So those are things that often do require speaking with an attorney and even retaining counsel so that you have your best opportunity of success. Next slide, please. In terms of, like we were talking about with the EEOC, the tips for successful proposed disciplinary action or investigation consultations, certainly if you actually have the document, you're going to want to make sure that you've sent the proposed adverse action or the decision before the consultation so that that can be reviewed during the consultation with the attorney. Also a good idea, again, to draft a narrative explaining the events that may have happened, certainly in terms of, if you have any sort of evidence or witnesses that may refute the allegations that are being made in the investigation or the proposed action. Always a good idea to jot those things down because that's something you're going to want to discuss with the attorney, because that's obviously going to lead to what your strategy is going to be in response or appeal. And like always, being on time and ready to discuss the issues is important. Now, with these types of actions in particular, you're often going to be getting into the idea of what the process is, the strategy, best practices, and the way ahead. But obviously being on time and being prepared to discuss all the issues really is to your advantage, because it's putting the attorney that you're talking to in the best position to have the knowledge in order to give you that advice. Next slide, please. So in terms of if you believe that you are suffering some sort of either adverse action or disparate treatment or threatened adverse action as a result of whistleblowing. Whistleblowing is, have you disclosed information that you reasonably believe evinces a violation of any rule, law, regulation, constitutes gross mismanagement, gross waste of funds, abuse of authority, a substantial or specific danger to public health or safety. There's also some specific things related to scientific research, or you think you're being retaliated against because you previously have filed an appeal or complaint or grievance. You may, depending on the agency you work for, have what's called an OSC complaint, or what they call an Office of Special Counsel complaint, alleging whistleblower, reprisal, or prohibited personnel practices. Now, not every agency has the ability to file with the Office of Special Counsel. However, there are often other options for those agencies if you do believe you've been subjected to prohibited personnel practices or whistleblower reprisal. So that's something that you would want to talk to an attorney about so that you could discuss, what your options are and how to best convey them. In terms of particularly prohibited personnel practices, that can convey a whole host of issues, not just retaliation. It can also be discrimination for non-EEO issues. Obviously, if you have discrimination that are based on EEO basis, you would be filing an EEO complaint, not an OSC complaint. It can be illegal hiring practices. And there's also some things that we call catch-all provisions. So it's a good idea, if you believe that you are facing some type of disparate treatment, particularly related to one of those issues, that you consult an attorney to discuss what your options are, what the best practices are, etc. Now, with whistleblower reprisal or prohibited personnel practice reprisal, you could ultimately wind up getting what's called an individual right of action appeal. What that is when the Office of Special Counsel, they are an independent federal agency that has the power to both investigate and actually take corrective actions based on your complaint. However, sometimes they cannot come to a resolution, or the resolution they come to is not satisfactory to you. In that instance, they then give you the right to be able to go to the Merit Systems Protection Board, and then you have the right to file, but there are specific timelines associated with that. So that's something, certainly, if you ever received an individual right of action, you would want to talk to an attorney about the way ahead, to make sure that, and do so promptly, to make sure that you are timely filing with the Merit Systems Protection Board. Next slide, please. So in terms of, obviously there are many, many issues that can ultimately fall under the umbrella of federal employment topics. But obviously, since we do so many, since we are a federal labor and employment law firm, some of the other common areas that we see involve things like disability retirement. So if ultimately you've suffered an injury, whether that injury is on the job or not, but that injury is now making it so that you cannot perform the essential functions of your position and you cannot be accommodated by your agency or reassigned, then you ultimately may be looking at disability retirement. And there's an application process associated with that ultimately for most agencies is going to go through OPM, the Office of Personnel Management, for approval. It is a very complicated process and very, very hypercritical. So things that may seem kind of obvious and the application itself seeming that it's very clear are not so. So it's often very beneficial to speak to an attorney about, number one, would this be something that you would potentially meet the criteria for, whether or not strategically it would be a good idea for you, but also then ultimately retaining counsel to have them assist you in drafting the application and submitting it, because you want to make sure that you really are dotting the I's and crossing the T's in this area, because unfortunately OPM is not giving most applicants the benefit of the doubt. They are very hypercritical. Another area that we frequently advise people on and ultimately represent them for are administrative grievances. So administrative grievances are different than grievances that fall under negotiated or collective bargaining agreements. Those types of grievances are generally handled by the union, but some people do not have obviously union representation and are not permitted to go through the negotiated grievance procedure. So in that case, we frequently represent people during that. There are often very specific timelines. You're usually often talking between 15 and 30 days. So that's something that if you believed you had some issue that you wanted to grieve, you would want to talk to counsel so that could give you kind of the strategy, the process, procedure, and potentially even represent you. Another area are what they call desk audits or reclassification appeals. So frequently when you are working in, for your agency, you may ultimately be being given greater and greater tasks and often performing duties that seem to be outside of your position description, or that even if they are within your position description, they seem to be not adequately compensated. And that a desk audit or reclassification appeal is an option to try and address disparities in pay, where you do not believe you're being compensated appropriately for the work you are performing. There are sort of two forms of desk audits. There is the internal, and then there's ultimately being able to go to the Office of Personnel Management, and that's something obviously an attorney can discuss with you. Another very, very common issue that we talk about is debt. Now, there are situations when people may receive erroneous payments or overpayments, or are being alleged to have either of those things, and the agency is now trying to come back and seek collection of those. There are opportunities to dispute debts and also seek waiver of debts. There are timelines associated with that as well, and that's something you certainly would want to talk to counsel about in order to get advice as to the best practices for challenging it, best practices for arguing for either waiver or relief. Next slide, please. So what are some bad habits to avoid? Now, like I said before, that some things can be related to nerves. Other things can just be kind of fear over sharing facts that might be viewed as sort of bad facts. It's not a good idea to withhold information from the consultation attorney. The benefit that you're gaining from talking to an attorney is that you need to share with them the actual information and facts, good, bad, and ugly, so that you can ultimately get the best advice. By hiding information that you might perceive is, unfavorable to you, well, you're ultimately hurting the advice that you get, and you're hurting potentially the case that can be developed thereafter. So never a good idea to hide information. And remember, you're talking to an attorney, so there's a privilege. So you can admit all sorts of things that do not leave the confines of that discussion. You know, it's ultimately in your interest to make sure you're getting advice based on the actual facts, not the facts as you might like them to be. Now, obviously, we talked about sending documents, but for a consultation, while there might be very specific documents that would be useful, there's often in a lot of these cases a lot of other documents that ultimately may be relevant if you decide to move forward with the attorney, but it's not a great idea to send hundreds of documents for a consultation because obviously the attorney cannot go through them with you during that call, and it often leads to some confusion. So you want to make sure you keep concise to any documents, especially those ones with deadlines, action items, and particularly those ones with important dates for, say, like appearances. You know, there may be some other documents that you may think are relevant, but sending sort of 30 pages of emails are usually not going to be particularly useful during the consultation. But not sending, say, the proposal for removal is actually probably going to be strategically bad for your consultation because the attorney is going to need to actually see the document that the agency sent, not just your recitation of what you think it says. Also, too, not every consultation, you know, as much as we want to hear your story, and we certainly are trying to give you advice that we would like to have help you, helping you does not necessarily always mean that we just agree with your perspective. In fact, a lot of times what we're trying to do is address the things that the opposing counsel or a judge might see in the case so that you understand the risk that's involved in pursuing the matter. So not listening to an attorney's perspective sort of defeats the purpose of a consultation in and of itself. It's not just to sort of have somebody cheerlead for you. It's about ultimately getting legal advice, good, bad, and ugly. Next slide, please. So this is our contact information. We also, obviously, as you can see, have a website. You know, our consultation staff, our client relations department, like we said, they're available most days, obviously online. You can book at any time, and they'll follow up with you. In terms of, you know, like we were saying before, very important if you've got something that is pending a deadline that you reach out as soon as possible, because you want to make sure that you're not preventing, number one, your own best opportunity for success, but also preventing the attorney from being really able to give you advice or at least take action on the advice that they're giving you because the deadline has already passed. So I'm going to look through a few of these questions and see if there's that we've gotten during these to see if there's any issues that we either haven't covered or are able to cover in them.
And if anybody has any additional questions, feel free to submit those via the chat.
Now, a lot of good questions here, but they are very specific, not so much to the idea of consultations generally, but in terms of maybe more specifically related to, say, like the EEO process. In terms of, you know, obviously individual issues, that would be certainly something, number one, I would suggest if you're having one of these issues, that's the perfect opportunity after this consultation to reach out and book a consultation so we can discuss your specific issues. In terms of the questions related to, I did see a few questions that were related to what they call a FAD, or a final agency determination. A final agency determination, as we discussed a little bit earlier, is after the report of investigation is complete. You will get a copy of a final agency determination. It also can occur after, say, a decision that's made by the judge. If you get one of those, there are appeals that are that you can make, and it's an appeal to what they call the Office of Federal Operations, or OFO. Generally, your appeal deadline is 30 days from receipt of the decision, but the 30 days is to give notice. You then get an additional 30 days thereafter to be able to actually supply the supporting brief and documents. But you want to, if you're going to be reaching out to counsel for assistance, it is better to do so in the early phases, because the more time you can give the attorney, sometimes, especially with a final agency determination that is based on a final decision from the judge, or even as a result of the report of investigation, you know, the attorney has to go through all of that information and often has to potentially look for additional information that was not collected. So the more time that you give that attorney is best for you, because, you know, ultimately you're limiting what can be gathered and the time it can be gathered if you wait until the last minute. Let's see. There was a general question about, you know, whether, you know, kind of, we'll call it a status question. Now, there are times that you may not be an actual federal employee. You might have been an applicant for federal employment. You may have been an intern. You may have even been a contractor. There are still options depending on the issue that you may be having, that allow you to take advantage of some of these things, like, say, EEO. So if you are in one of those positions and you were not an employee, but you were an applicant for employment, a contractor, a former employee, you still may want to reach out to discuss what your options are, if any. And doing so timely is important, because the same types of timelines apply regardless of whether you are an employee, former employee, you know, applicant for employment, contractor. Not to mention, obviously, if it's something that we couldn't assist with, it might be something that we can refer you to seeking assistance, or it might be a different area of the law. Particularly, say, with a contractor, it may not be something that a federal employment attorney would handle, but it may be something that a private employment attorney would handle, that we may have those services available as well. There's some questions about timelines. The average processing time for, say, if you filed your formal EEO complaint, you're going to, the agency has 180 days to do the formal investigation. In terms of how long it may take them to give you an acknowledgement or an acceptance letter of your claims, there's no typical time frame, but obviously if you don't hear from them in 180 days, you know that they're not going to meet their 180-day deadline for completing the investigation if they haven't even contacted you to let you know that they've accepted the claim, and or have the investigator has reached out to you to investigate. If that happens, if there are breaches of the deadlines on behalf of the agency by not completing the investigation timely, good idea to talk to an attorney, because there are options to wind up requesting your hearing at that point, even though you haven't received the report of investigation. And there's actually even the opportunity to seek out sanctions against the agency for failure to complete it. I don't really see any other questions that aren't probably too specific to answer during this consultation, because obviously we can't get into people's individual facts, because that would be potentially a breach of attorney-client privilege. Well, I appreciate everyone logging in today, and hopefully sometime in the future, if you do have any of these issues, we'll have an opportunity to speak individually on a call or a WebEx. I don't hope that you have these issues, but obviously if you do, we certainly are available to assist and potentially represent you.